Good afternoon, ladies and gentlemen. My name is Mark Rollins. I'm an attorney here in Washington, D.C. I also practice in the state of Maryland. Primarily area of practice is criminal law. Today we're talking about carrying a pistol without a license scenario. And that's basically how can two people who are arrested in a car be charged with the same weapon or the same drugs. But in this scenario we're going to say the weapon. So in this fact scenario that I'm going to discuss, because this has happened numerous of times, individuals stopped by the police officer for a traffic offense. Let's say he changed lanes improperly and the police officer pulls him over. Now there's two people in the car, and you have a driver and you have a passenger. The driver, in the middle console, open container of alcohol. They went to the store and someone opened up the container of liquor, and that will get you open container of alcohol. The officer sees the alcohol in plain view, and now he's going to arrest both individuals. Both individuals get out of the car, they're arrested, and the officer then goes back into the car and conducts a search of the car. He can arrest for that open container of alcohol, by the way. So he's now arrested these two individuals. He's put them into his car, and he then begins to search the automobile. Upon searching the automobile, he finds on the passenger side, he sees a handgun. Now, is it better for the officer, the individuals who are stopped, to now talk to the officer and explain to him whose handgun it was, who it belonged to, whose car it was, to give an explanation to the officer to try to get out of this trouble, or allow the process to take place and contact their lawyer? Now, if you chose B, contacting your lawyer, you chose the correct answer. One is that without these individuals talking, it gives the lawyer a lot more to work with. So he doesn't have the statements of those individuals. So now he can challenge the stop, whether the officer actually had probable cause to do the stop. And two, he can now challenge the actual gun that was recovered. Because that gun is constructively possessed, and in other words, neither one was in actual possession of it, and we call it constructive possession, the lawyer can challenge that and say which party had the actual more control or possession of that weapon. The lawyer would also hopefully do a thorough cross-examination about police procedures, whether they use the dusting latent print off the weapon or whether they use a super glue technique. So there's a number of things the lawyer could do to challenge that stop. But the only way that can happen is if the individual contacted the lawyer first, did not make statements. So in that fact scenario, there was a lot to work with and a lot a good criminal lawyer could work with in that fact scenario. And even if statements are made, lawyers can still work with that. But I advise you to contact a good criminal defense lawyer if you have a charge with criminal CPWL, as we call it, and stay tuned and watch our videos. All right, thanks for watching.